have a wonderful session here for you today, and there's been lots of interest, so we're really happy about that. And we've got lots of information to share. Questions around decision-making capacity can be emotional and challenging for caregivers and care partners to navigate. So today's session will help build understanding of what capacity assessments are, when they may be needed, and how they can support both the individual and their care partner. So we're pleased to welcome Dan today. Dan is a registered social worker with more than 30 years of leadership and clinical experience across the mental health, social services, education, housing, and justice sectors. Dan is the co-founder and executive director of the Family Mental Health Support Network of Niagara and has maintained a long-standing private practice specializing in psychotherapy, elder mediation, capacity assessment, and voice of the child reporting. Recognized for his work in program development, interdisciplinary collaboration, education, and policy-informed practice, Dan is passionate about supporting professionals, families, and communities through practical, evidence-based learning. We're grateful to have Dan with us today to share his knowledge, experience, and insights. So please join me in welcoming him. Thanks very much, Dan.
All right, so the link that you see right up front is to the list of designated capacity assessors in Ontario. There are probably about 150 assessors. And the reason I've got that up there is because, as you can see, this is an information session. This is not a solicitation for your business. There's enough work for 3 of me, and I don't have the formula to clone myself yet. So I'm all on my own with assistance of my assistant, of course. So if you do need a capacity assessor in the future, I suggest going to this list. And when you do call, my suggestion would be that you as clearly as you can describe the problem that you're facing when you get to the person. You get their voicemail or you get their email. Tell them what city you're in, because the capacity assessor is going to need to either travel or do it by video. Some assessors only do certain types of work. They don't do all of the types of capacity assessments that are out there, and you want to get somebody who can tell you right off the bat if they have the background and the experience to deal with the complexity or the simplicity of the issue that you're presenting them with. So that's the list, and I encourage you to use it. And of course, you're always welcome to call me, and if I'm available and I can help you, I will. Okay, so now into the meat and potatoes of what we came here to talk about: how to recognize when someone may need support with decisions related to personal care or property, and when poor judgment may be still considered legally capable. The keys to assessing this in this type of work are coming to legal opinions based on the law, and in this particular case, the Substitute Decisions Act, as to whether a person understands the factual information that is necessary in order to make the decisions that they need to make. So they need to understand the facts. And once it's been opined that they understand the facts, then we move on to, do they appreciate the reasonably foreseeable consequences of their decisions or their lack of decisions? And this is called decisional capacity. And I'm going to show you a big, huge definition, and I'm not going to read through it for you. You're going to get the slides afterwards, and you can read through it yourself, but I will speak to them very, very briefly. There's a key to be remembered, and that is that capacity fluctuates. People can be capable today and not capable tomorrow for a variety of reasons. There is also another term, aside from that capacity fluctuates, that needs to be understood, and that is the person who is a capable mismanager. We'll get to that. So under the law, they're capable to make their own decisions, and you or I might think that they're being irresponsible, wasting their resources and such, but they're still capable under the law because they understand the facts and they appreciate the consequences. We'll talk more about that later. Okay, so the next several slides, I said I'm not going to read through them, but you'll get copies of them. The highlight here is that we all have a right to self-determination. When I started out in social work, I started out rather late. I was already 30 years old when I became a registered social worker. I'm in my early 60s now. Um, when I was meeting people who'd been in the industry for quite some time, and I was, getting my own feet wet and starting out on the street, taking people sandwiches and juice boxes and cigarettes and bus passes and giving them directions back to the drop-in center where they could wash their clothes, those kind of things, going into the woods and finding people that were camping. The right to self-determination is something that took quite some time for me. Well, I mean, it took a little bit of time to really get it and understand it. That the person living out of their shopping cart might actually understand the facts and appreciate the consequences of how they live. And that's how they want to live. Similarly, the person who wins a lottery and spends all the money within a couple of years and is back in maybe struggling like they were prior to winning the lottery. So when you're thinking about your loved one, your family member, the person you're advocating for, who is either suffering from a particular health issue, such as dementia, that may come on very slowly or it may come on quickly, or somebody who experienced a drug induced psychosis, because here's where you understand my politics, where some criminal selling drugs poisoned their brain and damaged them permanently. And now, now they're impaired for life. They if they understand the facts and appreciate the consequences, then they have that right to self-determination to live how they want to live. The next key tenet is the presumption of capacity. When you call a capacity assessor, the first the first thought that that capacity assessor is going to have is, well, I'll speak for myself, but the law says everybody has the presumption of capacity, innocent before proven guilty. So when I go to meet somebody, regardless of how much collateral information I've received in advance, I arrive with the presumption that they are legally capable. Doesn't matter what I've heard, how many court reports I've read, how many collateral bits of information I've seen from family members, how many bank statements I've seen, and how many debt collectors are after them and paperwork that I have in my hand, or how I've seen through medical records that they are not able to manage independently on their own, yet they still think they are. When I arrive with the presumption of full 100% legal capacity to make their own decisions. And so you should prepare yourself for that as well, because emotionally you may be so overwhelmed having experienced caregiver burnout that you just don't get why the other people involved are arriving with the presumption of capacity. They need to do it. It's a duty. So this term, decisional capacity, is it refers to well, as it says, uh, rational decision making and the process that we spoke about earlier with the understand and the appreciate, and that they need to know what their reasonable, foreseeable consequences of their decisions or their lack of decisions are. I'm gonna kind of go back to the beginning and say something that I didn't say right at the beginning, which is obvious and you've all got by now, but a designated capacity assessor, and there are about 150 of us in Ontario. That doesn't include doctors in mental health units of hospitals. They can also take people's rights away from them to manage property and personal care, but they don't do it in the community. It's just the designated capacity assessors. So it's a huge responsibility to be able to go, poof, I opine that you are incapable and you now lose your rights. So these things are really important. And as long as you have a grounding that this is why it sometimes takes time and a process in order to take somebody's rights away from them, then then you're setting yourself up for uh, a less emotional turmoil as you go through the process. And the next is incapacity is domain specific. So the domains are in regard to property, the management of finances, not just bricks and mortar, not just paying bills, not just managing investments, not um, uh, taking care of dependents. There's much more involved in the management of property, and the word property means everything related to finances. So there's also the question of is the person's estate complex or simple? Are they living in receipt of ODSP and they just need to pay rent and buy food and pay for their telephone and their entertainment? Or has the person inherited an estate, or did the person build quite an estate of their own that needs to be managed now because they're no longer capable? Now, moving over to personal care, those of you who've seen power of attorney documents, which we'll also talk about, uh, there are 6 domains: decision making for healthcare decision making, shelter, safety, nutrition, hygiene, and clothing. And given where a person lives and what type of supports are available to them, natural and paid supports, uh, the uh, the evaluation is is going to consider all of those things. And a person may be incapable of managing their healthcare decision making because of the complexity, but they might be able to take care of their own clothing. They might know to dress warmly when it's cold and layered when it's warm, and they may be able to take care of their own hygiene. And if they have accommodations, that's important to consider as well. So next, this is also something that should be considered when you're looking at whether your loved one, your friend, or neighbor is incapable, is that taking a person's rights away and having one form or another of guardianship assigned, it is a last resort. Absolutely. It's a last resort to take somebody's rights away from them. Okay, so now getting into the observable signs. I created a big long list here, and I am gonna look at my clock because I want to leave plenty of time for questions. And when you ask questions, I can give long answers. I'll try and keep them short, but that's why I'm going to go through this part quickly. You'll have the slides to look at later. So, problems with understanding, for example, if the person is presenting with some confusion about these things here that you can see on the screen. Um, if the person formerly was a person of great financial competence, let's say that the individual had a very good middle class job, was responsible for making RRSP contributions, owns a house, paid it off, maybe remortgaged it and bought something else and then paid them both off, helped family members pay for education, saved themselves, and has plenty enough to pay for a fancy retirement home. But now they're having confusion, and now their decisions are seeming to be very different than they were a number of years earlier. That's when you can start, that's when you can really start wondering if they used to keep a clean house and now it's not clean. Uh, Next slide. If you have conversations with them and you notice short-term memory impairment, the issue with short-term memory impairment is if they have difficulty remembering new information or even recalling information that should be readily available to them and they've known for years, then they're not going to be able to use it effectively in order to manage for their own benefit. And then, you know, some of the other obvious things: losing track with conversations, difficulty communicating, aphasia, you know, deficits that oftentimes happen after stroke. Delirium is another one. For example, when I assess people who are living with delirium, usually in the hospital. It's advised. It's a, uh, a recommended procedure to wait at least 30 or 45 days before assessing the person if they've got delirium, because delirium frequently clears. If delirium doesn't clear within 45 to 60 days, oftentimes we're looking at a new baseline of ability to manage property and personal care. And and one of the reasons why an assessment might be done much sooner if a person is experiencing delirium is if they've got a lot to lose. If the house is about to be foreclosed on, if insurance policies, say a life insurance policy is, if they're going to miss a payment and then it's going to become invalidated, and the beneficiaries who are intended to be able to use that money to pay estate taxes or carry on their own lives and such, if that money is going to be lost, that might be a reason for doing it sooner. So um, you've probably been looking at these examples while I've been speaking, and so those are all some good ones. The last one here, the SDA guideline emphasizes that the person must have a working knowledge of their situation and enough cognitive ability to process information relevant to the decision. So, as I said, understanding the facts is not enough. In order to be found capable, a person must both understand the facts and appreciate the consequences. And when you're speaking with individuals like this, you're likely doing it because you care about them. And so I emphasize, be careful how you approach the conversations. You don't want to humiliate the person. You don't want to embarrass them, because my take on this is that most all people who are experiencing diminished cognition from their previous and former higher level, their higher baseline, they know something's going on. Like, they really do. I'll give you an example. I get too personal a lot of the times, but uh, both my parents passed within the last year and a half. My dad was sharp as a tack until 3 days before he died. 96 and 95 years old. They had wonderful lives. They were in love and they took great care of all their children. So they had good life. My dad, sharp as a tack until 3 days before he died. And my mom, she was a psychotherapist, and she had social skills that gave her certain graces. She could walk into a room and she was a classy lady, and she was intelligent, higher education, and she could fake it like you couldn't believe it. She she was 4 or 5 years into her dementia, and um, and she could fake most people out. They didn't think that there was anything wrong with her, but of course I knew better because I'm her son. So when I said earlier, be careful how you speak to people. Don't interrogate them. Just listen, form your own opinions, take your notes, and share that information with others who are going to be able to help you to protect them. Okay, because they know what's going on, and shame and humiliation is not something that we wanna do to people in their later years or in any years. Okay, so the next one, problem with appreciating consequences. Um, some people don't have that insight, and they lack insight into their disability. There's a word called anosognosia, which means lack of insight into diminished abilities. It's not it is fairly common, but again, it's also fairly common that lots of people do know what's going on and they're confused and frightened. The risks associated, if you see a person taking risks that they wouldn't otherwise take, if they think that they're just fine to drive, but they're hearing impaired and they can't do shoulder checks and their reflexes are slow, take notes on those things, and don't, again, I'll stop saying this, but uh, the dignity of the individual is important to protect. Like our parents protected us when we were toddlers. Uh, it's our job to protect our older brothers and sisters, or our aunts and our uncles, or parents when they begin to lose their abilities. If a person wasn't extremely impulsive in the past, but they are now, yep, same. Okay, so you're reading through that list, and if I want you to take your own notes, because when it's time to ask questions, you may want to use some of these examples in a question that you may want to ask at the end. You see the last bullet on this page, a tremendous decline in former baseline for managing personal and financial affairs. Um, a, uh, a regular average middle class person who's not really sophisticated in managing money would have still been able to pay their own bills and balance their own bank account and knowing they might need to go and borrow. But if that person loses the ability, then they could face eviction, foreclosure, penalties on mortgages. They could get tricked into getting reverse mortgages. There are lots of different opinions on those. It's a wonderful tool for people who don't have other financial resources, and for people who do have other financial resources, oftentimes they get tricked into these things. Another thing is that if you see that a person used to open their mail regularly and then they're no longer opening their mail, then that's important as well, because so much important financial information comes from banks and wealth management companies that you need to pay attention to, especially with some annual deadlines or the rolling over of investments, that if they're no longer opening their mail and they don't understand it, that's an issue. Here's some more. Crashing the car, little fender benders in parking lots. They can no longer reconcile their bank accounts. The bank will just take care of it. Not like most people actually reconcile their bank accounts, to be honest with you, but it's a simple matter of addition and subtraction and taking some factual documents, like the bill you get from for your telephone or your internet service, or your hydro or natural gas, and looking at your bank statement and making sure that that you are paying what you're supposed to be paying. We haven't got to paranoia on this, but distorted reasoning, delusional thinking, false beliefs, those are things that you want to listen to. And I go back to if you've ever got into an argument with a drunk person and you see how futile it is, but it might be fun, right? When you're dealing with a person with diminished cognition, somebody that you care about, it's not going to be fun. So just listen to what they have and listen to their reasoning. And one of the statements that I have used frequently over the years is I don't know if the person asks me if I agree with them. I say, well, I can't tell you if I do or not because I don't have enough information. So could you explain that again to me, maybe in a different way, what you're trying to impart? And that way you can listen to them furthermore, and you can form some opinions of your own, gather some information about distorted reasoning, false beliefs, delusional thinking, that kind of thing. These are some obvious ones, some possible signs: repetitive questioning, saying the same thing over and over again, 5-10 minutes later. When it gets very serious, forgetting family members, vulnerable to scams, and some of you may have seen there are books out there that talk about the different scams that are going on, and they are nasty. I've seen people. I've gone to do assessments where a moving truck has been parked in somebody's driveway, and a young family is waiting to move into the house, and the senior citizen there never even knew that the house had been sold out from underneath them. And then the sheriff comes along a couple hours later and evicts that senior citizen, and then somebody helps them. 4 or 5 days later, they get back into their house because it was a scam. Both parties were scammed. The young family who probably lost their down payment, as well as the senior citizen who was in the house. So here's the second bullet from the bottom. This is important as well. Early dementia, or I would choose some better words for that. Early symptoms of dementia. Early symptoms of dementia can still leave a person capable. Just because the person has the label of dementia does not mean that they're incapable of anything. They may still be able to revoke a power of attorney for property or personal care to give it again to somebody else. They may still be capable of testamentary capacity, changing their will. They may still be capable of testifying in court if they have a legal action going on. They may still be capable of marrying and divorcing. Those are just some examples. Similar, right here, people with illnesses such as bipolar, schizophrenia, other severe psychosis. Remember, the test is domain specific. A person can still be capable of managing their property, making their financial decisions, and taking care of some of the domains or all of the domains in the personal care area, even if they have symptoms. If those symptoms don't affect their ability to understand and appreciate, exactly related specifically to the domain that we're talking about, then they're still capable. A little bit of repetition here. Reference to stroke survivors. Stroke survivors and people who need accommodation, for example, hearing impairment, or people who are sight impaired, they may need accommodation to get through an assessment, or even the family members may need to develop some better skills at communicating with that person before you really come to the belief that they are incapable and at risk. I'm looking at the question. So you've seen an awful lot here on how to, on what you can do to recognize some financial warning signs. Again, I appreciate you allowing me to go through this very quickly. You'll have a copy of it. So hoarding or reckless spending when it wasn't there previously, confusion about assets, inability to budget, wasting money, or just not paying bills like they would have in the past. I mentioned capable mismanager. You see at the very bottom, a person can still be. Let me give you an example of a capable mismanager. This is a hypothetical. This is not a real story. Imagine a husband and wife. The husband's a school teacher. The wife is a nurse. The husband has a gambling problem, and the wife feels that the marriage is falling apart because there's something wrong with them, because they've got 2 young children and they're about to lose their house because the bank's going to repo it, and she wants him assessed so she can manage the money. Okay, I go out to do the assessment, and it turns out he is fully aware that if he keeps gambling and losing, that they're going to lose the house. She's going to leave. She's going to take the 2 children. She's going to go move in with her parents. He'll probably end up living on couch surfing amongst his friends' houses, and then he'll probably end up getting a rooming house somewhere, and he'll be unhappy. And he knows that he might start drinking more than he already does, and he's going to pay tons of child support. And he doesn't like it, but he just wants to keep gambling. He knows what the consequences are. He is a capable mismanager. And so there are plenty of other examples of capable mismanagers out there. All right, when we're talking about personal care, here yet some more examples. Hygiene deteriorating, even to the point where the person simply smells awful, but they're not going to get sick, or because of their diminished hygiene standards, there is a possibility that they will develop infection. Nutrition is a huge one. If a person isn't eating properly, then, well, the obvious is they're not going to get the supplements to their stomach to be distributed to their organs and to their brain and through their blood system. And anybody deprived of appropriate nutrition, especially a vulnerable person, is going to decompensate even faster. If they forget how to take care of their property, their house, their garden, their roof, um, I have to do things such as even ant control at this time of year because the ants want to start coming into the house. Um, that kind of thing. If I stopped taking care of that, it would be an issue. Medical care. Uh, some people have multiple medical care needs and they need to balance 3, 4, 5, or 15 medications in a day. If they don't know what the medications are for and which medications are contraindicated with each other and what the risks are of not taking the right amount at the right time or taking them at the wrong time of day or missing them over a few days, then we need to consider whether they're incapable of making decisions related to their own medical care. And physical safety, uh, going outside and trying to shovel the snow when the person has balance problems. Okay, so this list goes on and you've got it to reference later. I already mentioned that capacity is presumed, the presumption of capacity. It's domain specific. Bad decisions do not equal incapacity. People are allowed to refuse treatment, spend unwisely, live in risky conditions. Like I would never go bungee jumping, even though it's probably safe, but lots of people would. And mountain climbing or here's an example that I don't think does fit. Speeding on the highway. That doesn't count because you're putting other people at risk. So there's a risk factor there. We already talked diagnosis alone is insufficient. Capacity focuses on ability. And that's pretty much that for signs that you can look for. The next question was what a formal capacity assessment involves, who conducts it, and the associated costs. So let me answer this while you're looking at the slides, and then I'll go back over the slides, and if there's anything I haven't touched on, I'll mention it. So a formal capacity assessment, there are many different types of them, and I've listed some of them here. If a person has a power of attorney document, and good planning would see that we all have power of attorney documents, or those of us who are capable of meeting the legal threshold, the criteria, which are in section 8 and 47 of the Substitute Decisions Act. If you're allowed to give a power of attorney to somebody, then you should be able to you should do it. So if your family notices that you might be incapable or they're worrying, most power of attorney documents, I'd say 95% of them out there, they have a clause in them, it's usually section 3, that says that although this document is legal and legit, in order for the attorney to begin exercising the authority, that the person must be found incapable of managing property or personal care in none or one or more of the 6 domains of personal care. And that is the most simple, straightforward way of protecting yourself and anybody protecting themselves. You would call a capacity assessor. And in Ontario, it is only designated capacity assessors that have the authority to do that. Even if the document says that it's the person's doctor, or they could say whatever they want, under Ontario law, it has to be a designated capacity assessor. There is the exception, of course, if the person is in a mental health unit of a hospital, the psychiatrist can do it. And the assessments that they do are quite different in the process. They just need to check a box and put their signature, whereas we need to write long formal reports. For me to write a report, a simple report takes an hour and a half, 2 hours. after I've met the person and done the collateral gathering in advance. And a complicated one could take, could take 3, 4 days, 5 days of working at my desk to write it. So formal capacity assessment, another example of a formal capacity assessment, one of the most common ones is called a Section 16 capacity assessment. If there is no power of attorney document and you are concerned about the individual, you can request from a designated capacity assessor a Section 16 capacity assessment, where the assessor will gather the collateral information, will have you sign, the requester, if it's you, sign a Form 4 request to do the assessment. And then the assessor will ask to be introduced to the individual, will meet the person, will give them a rights advice. And these assessments that I'm speaking about right now so far are all voluntary. So the rights advice comes up front, and if the person chooses not to participate, that's it, it's over. And so the rights advice goes something like this, and the assessor will prepare the requester to have an understanding in advance of whether the person is willing to participate. And I tell you, most people who are not capable, who are incapable under the law, the rights advice goes right over their head. They don't understand it. And so it's not a matter of consent, because a person who's incapable cannot consent. It's a matter of assent. And there's a difference between consent and assent. So you need to know whether the person that's going to be assessed is going to nod their head to what I'm about to say next. I say, hi, my name is Dan Silver. I'm a designated capacity assessor, and I'm here to assess your capacity to manage property. And that means all things related to the management of your finances. While we're talking, I'm listening to give a legal opinion on whether you understand the facts about what you need to manage, and to, if you appreciate the consequences of the decisions that you make, or the lack of decisions that you make. In order to be found capable, you have to both understand and appreciate, and to be found incapable, you just need to not understand or not appreciate. When we're done our assessment today, if my opinion is incapable, I will write a report. I'll provide to the Ministry of the Attorney General, Public Guardian, and Trustee. I'll give a copy to you, and then they'll be in touch with you. And the last thing you need to know before we get started is that this assessment is voluntary. And so, just by the way, I remind you, I'm speaking about 3 times the speed right now that I normally speak, because I want to get the information across to you. So when speaking with an individual, there's much compassion. It's slower. There's body language being explored while the assessor is meeting with the person, so that they can make sure that language that appears to not be understood is offered again in layman's terms, so that the person has the greatest opportunity to understand it. So if you do a Section 16 capacity assessment, then it goes to the public guardian. If you are the requester, or there's somebody else in the family, or somebody who really cares about them and will do a better, would like to replace the public guardian, that's the actual legal language. Application to replace the public guardian, that can be done. An application can be made to get it back. And so that if it was one of my children, I might apply to replace the public guardian so that I could manage their property for them. Now, when we're talking about this to this point, we're not talking about personal care, healthcare decisions. That's totally unrelated to the management of property, and the public guardian's office rarely takes care of that. Okay, so the cost of what we've talked about so far, to go to your lawyer, you need to talk to your lawyer about what they charge you to create a POA document. Might be $1,000, might be $500, I'm not quite sure. You can also download a copy from the Attorney General's website, and you need to take a very good look at it, because I believe it's the type that's activated immediately. So you need to put some conditions and restrictions in there. And of course, that'll be free. It'll just be your time. You may want to take it to a lawyer afterwards and have it notarized. That might be a good idea. If capacity is questionable for the person who's giving it, then you might want to have them assessed first. Or you might just want to have a lawyer do it, and then the lawyer recommend whether the person should be assessed. So a Section 16 capacity assessment that I mentioned, you could be looking at anywhere from $1,000 to $1,500 to have an assessor go out and do that type of assessment. Now there's another option, as long as we're on the second one. What is a formal capacity assessment? Who conducts it? What's it cost? If the person is not willing to do a Section 16 capacity assessment, to let the public guardian manage, or for you to replace, a guardianship application can also be done for property and for personal care. Those are a bit more expensive. Frequently, families with children with intellectual disabilities or autism, or somebody who's been injured in an automobile accident and has a traumatic brain injury, where there may be a lawsuit for tort claim and medical expenses to be paid for life. Somebody needs to make decisions around that for the individual. So a guardianship application requires a capacity assessor, and in some instances, 2 capacity assessors. You're looking, I would say, you'd want to budget between $2,000 and $3,000 for the assessment, and the lawyer's costs are the lawyer's costs. I can't tell you what those are. I mean, I could guess. I would say budget $5,000 to $10,000 for some lawyers, maybe less. Some lawyers maybe more. Now, I want to get to questions. We're already at 1:45. I think we already covered the last bullet point here. What options are available to protect a loved one who becomes incapable without prior planning? And that would be the Section 16 to replace the public guardian or guardianship applications. Okay,